It's great to see so many of you here. You know that you've got a lot of students when some of them are actually sitting in the front row. So I guess that's what PISA and the LP faculty will get you. Welcome to our first Saltman Center for Conflict Resolution event for the fall. I hope to see all of you at our other events. I think that most of you are students, but a few of you might be attorneys. If you're an attorney and you're here in part to get CLE credit, you need to fill out the forms. In the back was Karen Tigert, and the forms are back there for sure near the door, so you can fill those out to get your credit. John Lande is a friend of mine. He's a former colleague of mine. We used to teach at the University of Missouri together, where he still teaches. As many of you know, University of Missouri has what many would regard to be the top program for alternative dispute resolution or conflict resolution in the country. I won't say that, but many might say that. One of the things that John does there is he directs the LLM program that they have on conflict resolution or alternative dispute resolution. If any of you, after you finish law school, would like to spend another year learning more about alternative dispute resolution, talk to John Lande. It really is a great program. I taught in that program, and the students who do come through that program are great. A lot of them come from other countries, and it really is an enriching experience to learn about dispute resolution and to mingle with students from so many other places. I've also worked with John as a co-author. We're actually in the process right now of writing an article that discusses the appropriate role of alternative dispute resolution in legal education, and it's been really fun for me to work with him. Throughout his career, John has done a lot of great scholarship, and what he tends to do is to write about the intersection of litigation and alternatives to litigation, and I think you'll see that his talk today fits right in with that. Before he got to the University of Missouri, he taught a couple other places, and before that he has both a law degree, which is from Berkeley, as I recall, and also a PhD in sociology from the University of Wisconsin. For those of you who aren't familiar with the University of Wisconsin, that's a really top school for programs like sociology, and he worked there with Mark Galanter, who's a really leading sociologist of law. Those of you who are in my class actually read a short article by Mark Galanter for our first day of class about the vanishing trial. And if you were more familiar with Mark Galanter's work, you'd see that in many ways John has built on Professor Galanter's scholarship as well. Anyway, I don't want to hog any more of the time. We're really fortunate to hear John Lande. He's going to speak on planned negotiation. He's going to explain to you what that is. With no further ado, my good friend John Lande.
All right, as you may have been seeing, we've been tinkering with the microphone, and it looks like you can hear in the back. You probably can hear well enough without the microphone, but we just want to make sure. If any of you are having problems hearing, sort of wave me down or something, usually that's not a problem. I'm going to take this other microphone down so you probably don't even need that and won't distract from my beautiful image. A couple of things. First, I want to thank Jean for the invitation and the wonderful introduction. As she has said, we are friends and colleagues, former colleagues at Missouri, and current colleagues working on this wonderful article together, which has been just a wonderful experience. Those of you who are students here and are interested in dispute resolution, which I assume is most of you, unless you're mostly here for the free pizza, may not appreciate what a wonderful faculty member, scholar, teacher Jean is. You go to law school and you kind of end up at the law school you end up at, and you aren't necessarily coming for Jean Sternlight. Let me tell you, she really is highly respected and a wonderful colleague. And I could go on, but I want to talk about all this stuff first. So thank you very much, Jean, and thank you all for coming. I want to say a couple things also just to complete the plug about the LLM program. In the back we have two pieces of literature, and if you're interested you can pick them up. Mostly they will refer you to our website, so if you're really interested you can learn more information there. Generally, the folks who come to our program are folks who have been out of law school at least a little while. We've had a couple people who come straight out of law school. It probably does make sense to have some more experience. Of course, I understand a lot of the UNLV students here already, are non-traditional, have had some work experience. You might be interested. So if you are, I'm happy to talk with you about it. Take a look at our website. Feel free to email me or give me a call. let me see. I want to find out who you all are. So I gather that a couple of you anyway are probably students. Can I see a show of hands? How many of you are UNLV law students? Whoa, a bunch of you. How many of you are faculty members here? Okay, well, it's good to see you all. Some of you are practicing attorneys. Can I see a show of hands there? Well, that is terrific. Some of you are judges, is that right? I thought, no, okay. Any of you practice collaborative law? Okay, we got one. So Bob can correct me when I fall off the track. What I want to do today is to talk about collaborative and cooperative law and why, sort of how they work and what the potential advantages are. For those of you who are students, these are things that obviously you're not going to be doing now, but that you might think about including in the portfolio of services that you offer in the future when you're out in practice. I'm actually going to direct this next question to the lawyers in the group, and I'm curious, among the lawyers, have any of you ever settled a case? Some of you, I see. Yes. I'm curious if there are any of the lawyers in the group who have not settled a case. Probably hard to imagine. You probably know, Gene was talking about the vanishing trial, and Mark Lande talks about a well-known statistic that only a very tiny fraction of cases that are filed go to trial. In the federal courts, it's like less than 2%, and the state courts it may be 5 to 10%. So not every case that, it doesn't mean that the other 90 or 98% of cases settle. There are other kinds of dispositions, but a large proportion of cases that are filed get settled. And of course, there are a lot of cases that get settled where there's never been a filing at all. So, I mean, as a practical matter, virtually every lawyer who gets involved in dispute resolution and litigation settles cases on a regular basis. You can't, the system wouldn't work. It would grind to a halt, both on the civil and criminal side, without settlement. So, for the lawyers in the room, I guess I'm wondering if you've ever had an experience where you've settled a case, but you thought that, gosh, in hindsight, it should have been settled sooner. And you, I'm seeing some smiles, nods of heads. Why didn't the case settle sooner? Bob, I saw you nodding. So, and since we chatted, why have cases not settled sooner?
People are, first of all, polarized. Number two, they may believe in the righteousness of their case and want to litigate for a while. Number three, they just really want to punish the other side, make them pay for something. And then four, they haven't faced the reality of what may happen to their case until they've gone through the process for a while.
So people, just the parties in particular, may just not be ready to settle. And that's often the case. Lawyers may not be ready to settle often at the outset. I mean, you can take a look at this graphic, which there are packets that hopefully you all received, and this graphic is there. What you see here on the left side is the traditional litigation model. And what happens is that people will start in litigation. Someone will file a complaint, and then the defendant will file an answer, or in a family matter, depends on different states have different names for it, but you have the pleadings, and then you're off and running. Well, after you file the pleadings, well, of course, you could settle at that point, but a lot of lawyers are reluctant to settle at that point because they don't know enough, and that's a legitimate, understandable concern. They want to do discovery, which, of course, the law students are learning about, and that can take a while. And of course, as the litigation proceeds, sometimes people get to feel more friendly and open, but often it actually exacerbates the tensions. And so people may not settle or be oriented to settle and negotiate until close to the end. You've probably heard the expression settling on the courthouse steps. And what happens is you go to court, or maybe you have a settlement event, maybe there's a deposition, maybe there's a summary judgment motion, and people start to say, well, maybe I should start to think about settling at this point, but it's late in the process. So you can see that often what happens is that you'll start litigation, and if there's negotiation, it's often after litigation has proceeded for a while. By the way, I should say with all of these graphics, these are obviously simplified representations, and these don't reflect how life goes on in every single case. Some cases, people will negotiate in the traditional model even before you start litigation or early on in litigation. But sort of in a traditional model, there'll be people starting in litigation, and at some point, often late in the process, they will negotiate. Now, there are these two other models, this what I'm calling big C cooperative model and big C collaborative model, which are a little different. And if you just look at the graphics, any differences that you can see between these two on the right, the cooperative and collaborative, and the litigation model? Okay, I can call on people. You know, I'm a professor. I've got a license to call on people. Any differences that you can see? Go ahead.
Well, the clients talk to each other in the cooperative and collaborative versus in the litigation, they never speak to each other.
Right. I mean, one of the things is that you have this four-way conversation. So the parties are talking to each other, the parties are talking to the other lawyers, so everyone has a chance to talk to each other. This is what's called a four-way meeting, where the lawyers and clients get together. In traditional litigation model, that can happen too. It's relatively rare. Why do you think that might be rare? Imagine that, particularly for those of you who are law students, you're imagining you're going to be in practice, you're representing. The collaborative in particular is used primarily in family cases. Why might you not want to have a four-way meeting? Go ahead.
Ex parte contact rule?
Could be, although actually that's not a problem. A number of people will raise that. Basically, the concern is there's an ethical rule that precludes a lawyer to talk, if the other party is represented, to talk with the other party. But if it's in the presence of the other lawyer, I don't think that that's actually a real problem. So if you have, I mean, this four-way meeting, I don't know that anyone has ever suggested that that's a violation of the ethical rule. So, I mean, theoretically that could happen, but I don't think that that's a big barrier. Why else might you not want to have a four-way meeting? Go ahead.
Acrimony between the parties.
Yeah, you're afraid that this is going to blow up, and that, you know, if anything, the lawyers just want to keep the parties apart, and particularly if you're in a traditional litigation process where there's already some acrimony, there isn't necessarily an expectation that you're going to cooperate. If you're going to settle, it isn't necessarily, I mean, often people settle, but they will do it sort of grudgingly and sort of with their teeth gritted. So having everybody in the room may not actually promote good negotiation. Another thing is a lot of lawyers are afraid what their clients are going to say. So they would much rather just have this lawyer-to-lawyer conversation. So you can see that a very common pattern is lawyer one and party one will talk to each other, and the lawyer will say, well, do you think it's time to negotiate? I think this may be a good thing for you. Let me talk to the other side. Is that okay? And here's what I would propose. And so the lawyer one will then talk to, if the client says okay, then we'll talk to the lawyer two and says, here's what we're thinking about. What do you think? And then if lawyer two says okay, makes sense to start thinking about this, lawyer two says, well, okay, I'll talk to my client. And then they have that conversation, and there's a response, and maybe they'll say, well, that's just great, we're ready to settle completely on the terms that lawyer one suggested, but often there'll be a negotiation back and forth. So this is like a game of telephone. So although there's this box that makes it look as if it's all in one room together, actually this may be over the phone, maybe exchange of letters, maybe emails these days, but it's an inefficient process. And it's one where the parties don't talk to each other. The lawyers may actually instruct. It's very common for lawyers to tell their clients, don't say anything to the other side. Why? Because they're afraid that they're going to make some admission that's going to hurt their legal case. So it's actually, making communication more difficult. Now, sometimes that's actually a very constructive and appropriate thing, and if you're representing a client, that may be a very wise piece of advice to give your client not to say anything to the other side. Sometimes lawyers are afraid cats. I mean, we're built to be that way. Our job is to protect our clients, and we're afraid of all sorts of bad things happening, and our job is to protect them against that. So it's understandable that we're very cautious about doing that, and part of that is we want to control things. And again, often that's for very good reasons. So, I mean, part of what you have here is an inefficient process. If you're ultimately going to settle the case, which as we say, the vast majority of cases are going to get settled. So there's been a movement, particularly this collaborative model, and you'll see that there's, the collaborative model and the cooperative model are very similar. The collaborative model is something that has been developed. It was originally started in 1990 by a lawyer in Minneapolis named Stuart Webb, and he developed the idea for this, and it really started taking off around 2000. And since then, in the last 10 years, this has gone gangbusters. There is a very vibrant collaborative law movement. Again, it is 99% of the cases are in the family law context. There have been people who've been trying really hard to have it used in other kinds of cases, so far with limited success, although they're continuing to work at it. And hopefully they will develop more of that. And we'll talk more about what this collaborative model is in a second. Cooperative is a much newer thing. It's a variation of the collaborative model in a number of ways. And basically it started in 2003 in terms of people actually doing it. There's a group in Wisconsin that started doing it, and there's a much smaller number of people doing it now. With collaborative, they've got an international organization, the International Academy of Collaborative Professionals, and they have thousands of members. They have a large conference. They have a huge infrastructure. They have a very mobilized and motivated cadre of practitioners, and it's an interdisciplinary group of practitioners. Originally, it started as collaborative law, and because most of the cases are in the family context, they use a lot of other allied professionals, mental health professionals and financial professionals in particular. And it's just a very large, vibrant movement. Now, so that's kind of a background about collaborative and cooperative. And again, I use the term big C and little c, big C for both of them to distinguish the idea that these are formal processes. I mean, these are distinct processes. It's not just saying, okay, if Gene and I are in a negotiation, we're going to be cooperative, we're going to be friendly, we're both good people. And lawyers do this all the time. For many of you law students might think, oh gosh, lawyers are like cats and dogs fighting all the time. And that certainly does happen. I think there's an exaggerated image of that. Lots of lawyers, particularly after a period of time, want to develop a reputation for reasonableness. They realize that life is too short, it's not in their client's interest, and that they can get a lot done by working cooperatively with the other side. So if Gene and I are working on a regular case, I call up Gene and say, hey, my client, I think it's appropriate to settle. I think my client would be interested. Let me share some information, some documents with you. Would you be interested? And we can go off sort of operating in a reasonable way, not necessarily in this formal way. So I would call that a small c cooperative or small c collaborative process as distinct from the formal process here. The difference here, well, let me show you what the graphics reflect and start with a collaborative model because that's the predominant and earlier one. You can see that as distinct from the traditional process, you start off in negotiation. And litigation is only an afterthought, if needed. And hopefully you don't even need to get to litigation or contested litigation. In some states, the parties will file a case just to sort of get the clock running. In many states, there's a waiting period until you can actually get a final decree of divorce, and so they want to get the clock running. So they're technically in litigation, but they're not using the full panoply of the litigation process. And in fact, courts are now being asked to essentially have them leave the court, the case management system. A lot of courts have a system where they're pushing cases through on a pretty tight time schedule. And so the collaborative law folks want to say, well, take us off that time schedule so that you leave us time to negotiate. So basically, before you get into litigation or any kind of real serious contested litigation, you're going to negotiate. And again, as someone pointed out, you're going to have these four-way meetings where the parties are talking to each other, the parties are talking to the other lawyers. One of the things that happens, again, for the law students, you should know is that you are going to be hated. I can predict this with some degree of confidence. The other party in cases where you're litigating is going to think that you're the devil. And you're not the devil, at least not most of you. But they don't know that. They're going to just get all these nasty letters and interrogatories and all sorts of things, and they're going to blame you. And one of the things that will happen is if you're in a four-way meeting, they're going to see, and particularly if the goal is to come up with a cooperative, reasonable resolution, you're actually going to try and be the good, decent, honorable people, reasonable people that you are. So the idea is to try and promote a good environment for negotiation. The key element of the collaborative model is illustrated by this solid bar here, which represents what's called the disqualification agreement. Sometimes people refer to it as the collaborative commitment or a withdrawal provision. I think actually the technically correct term is the disqualification agreement. It doesn't really matter for our purposes. What this means is that the lawyers, if there is litigation, the lawyers are blocked from being, the collaborative lawyers are blocked from being part of the litigation. There's a written agreement that the parties and the lawyers sign called a participation agreement. And what it says is if there's contested litigation relating to that matter, then the lawyers may not represent, neither lawyer may represent their client in the contested litigation. So the clients need to hire new lawyers if they want lawyers in the litigation. So obviously, I mean, you can't preclude parties from litigating, but unless you have a mandatory pre-dispute arbitration clause. But we're going to put that issue aside for the moment. The parties can always go into litigation. It's just that their lawyers have to be left behind, and they have to hire new litigation lawyers. The major distinction between cooperative and collaborative is this dashed line, so that if needed, the parties can litigate and retain their lawyers, and they can go back and forth between the negotiation and litigation. And this is based on the study that I did of the lawyers in Wisconsin who do this cooperative process. There are advantages and disadvantages to both processes. I mean, one of the things that is, it would be funny if it weren't so sad, some of the collaborative and cooperative folks don't get along so well. I mean, it's really pathetic. It's a charitable way of putting it. But some of the collaborative folks think that this cooperative stuff is anathema. It's a fraud. It's just really inappropriate. It's confusing parties. Some of the collaborative folks think that don't think well of the collaborative model either. And my view is they're both legitimate processes. There are advantages and disadvantages to each one. There's a real virtue for clients in giving them a choice between the two of them. And so, as I've just said, I think they're both legitimate processes. Let me see if I can get from you what you think some of the advantages of the collaborative model might be. Any of you? Go ahead.
You have more of an incentive to solve the problems because if it does go to litigation, then you're not getting anything out of it.
You being the lawyers.
Yes.
That's right. It creates this idea that the lawyers, I mean, the collaborative lawyers can't benefit. So there are no more fees. There's no sense of satisfaction of success from helping a client through to the end and getting the ultimate desired result of a good settlement. And part of it is the idea is that it's going to keep the lawyers from even thinking about what would go on if they were going to litigate, because they're not going to be litigating. So part of it is, and one of the things that many of the collaborative lawyers will say is that when they're trying to do, essentially, often many of them will have done an informal small C cooperative process. It's very hard because they're always thinking about, well, if we can't settle, what's going to happen if I go to trial, and how can I use what the other side is saying in a way to benefit my client? So when you have this disqualification agreement, it cuts out most or all of that incentive to be thinking by the lawyer's perspective about what would be going on in litigation. So you're going to be focused entirely on the settlement. What about from the party's perspective? Why would the party want to use a collaborative process?
I think in the process for a trial, it's either a win-lose, whereas in this process, if the parties come to an agreement, then it's possibly a win-win for both of the parties.
Okay. Of course, that's true. But one of the things is you can see is compared to a cooperative process, assuming that they had a choice between a cooperative and a collaborative, what would be an advantage of the Big C collaborative? Because the Big C cooperative would also have the potential for a win-win. So what's the advantage for the party?
If they have to start all over, they have to call retainers all over and go through a very expensive process.
Well, that sounds like a disadvantage. Why is that an
No,
advantage?
I understood what you were saying, that's a reason why parties would want to stick with the collaborative model to get it settled, so that they wouldn't have to go get other attorneys to litigate.
That's exactly right. Essentially, what it's doing is it's making it a lot harder to get to the litigation. Essentially, people will talk about, throwing the keys to the courthouse away or locking them up or, locking their hands, stop me before I kill again, stop me before I litigate again. It's just going to make it harder. They can still do it, but the costs are going to be higher. It's going to be more of a pain in the neck to do it because you have to start hiring new lawyers, paying new retainers. So it creates a strong incentive for staying in the negotiation process. So those are really, I think, the big advantages and the motivation. And actually part of it also is that because it keeps people focused so much on the negotiation, there's a much more constructive attitude and atmosphere for negotiation because they are really focused exclusively on the negotiation. So sounds pretty good. Any problems with this Big C collaborative process that you can imagine? Why might you, if you were a party, why might you be wary about a Big C collaborative process?
Well, let's say one party doesn't have much money, and one party does have a lot of money. The party that does have a lot of money might have an advantage in that the less rich party will have more of an incentive to settle because the richer one can go ahead and start litigation if they have more money.
That's exactly right. There's a potential for manipulation here and settlement pressure in the collaborative process. And basically whoever sort of is willing to stick it out longer can put the pressure on the other side. And there's actually been some research done. There hasn't been a lot of research done on collaborative, and other than my study, none on cooperative. But there have been some cases where people have reported just that. And in particular, there's a concern about cases involving domestic abuse. I mean, one of the things is if you can imagine where you have an abuser who is manipulating and pressuring and controlling the victim, this would be a way to kind of keep them focused in this process, keep engaged, which is often a motivation of an abuser. And one of the things is that some of the research suggests that the lawyers may be so focused on making the collaborative process work that even the abused clients may feel that his or her lawyer may not be providing as much advocacy as they would want and support. And so they at some point may say, well, gosh, this isn't working so well, I'd rather go to litigation, but the barriers that we've created are too strong, too big, that we are wary about doing it. There is now in the process, the very final process, being drafted the Uniform Collaborative Law Act, the Uniform Law Commission that used to be called NCUSL, National Conference of Commissioners of Uniform State Laws, which has promulgated all sorts of laws. Probably the most famous one is the UCC, the Uniform Commercial Code, has been working for the past 2 years to develop a Uniform Collaborative Law Act. I was an unofficial observer and have attended the meetings. One of the things that's included in the Uniform Collaborative Law Act is a provision that essentially creates a rebuttable presumption that cases involving domestic abuse, domestic violence, should not go into collaborative law. Now that presumption is rebuttable, so that if there are certain conditions are met, if the parties are aware of this, and if there's adequate provision to provide for the safety of the parties, then that's okay. But the concern about potential abuse is there in the litigation, in the collaborative law process. So that would be the concern about the collaborative case. What's the advantage of the Big C cooperative process? Why might you, if you were a lawyer or a client, want to use the Big C cooperative process? Go ahead.
If you're in a posture to litigate the case, you might have more incentive to settle.
Okay.
Prevent litigation.
So in some ways it would create, I mean, sometimes people don't get reasonable without a threat of litigation. It would be nice if, everyone was like Gene and me and we were just good, reasonable people all the time. But sometimes, Gene, you have to kind of threaten her with a stick in order to get her to be reasonable. If I'm prepared to litigate, and we're both prepared to litigate, sometimes, there's that, sort of, to get peace you need to prepare for war, which people may or may not buy that philosophy in terms of foreign relations, but in terms of the analogy for litigation, sometimes people are only ready to settle if they are, to some extent, prepared for litigation. Now, in the traditional litigation model, that's the theory entirely, that you're going to really, gear up for war. You may not settle until you're literally on the courthouse steps. And that's sort of the extreme version of it. This is sort of an intermediate version where there's the potential of going to litigation, but the idea is you're going to start in the potential for litigation, but you're going to start in the negotiation. Any other reasons why you would see that you might want to have a cooperative process? Big C cooperative? Go ahead.
It seems like lawyers would be more willing to take part in that just because they won't get cut off before litigation starts. Like if it were to start, they can see through the entire case. They'll be more likely to take on cases using that method.
That is certainly true. I mean, one of the things is that there has been, as I say, this tremendous movement, and there are thousands of lawyers around the United States and actually around the world. It's as a social movement, it is phenomenal to see what the collaborative lawyers have done in this last 10 years. So there are some lawyers who are willing to do that. There are a lot of lawyers who are wary about doing it, particularly in non-family cases. So let's just move out of the context of family law. Imagine that you've got a big civil case or a medium-sized civil case, a contract dispute. So why might you, as a lawyer, be wary about why might you prefer to use a Big C cooperative process instead of a Big C collaborative process?
Actually, I have one this afternoon. We insist we're doing a negotiation from the hotel.
Can you speak up a little? I can hear you, but I'm not sure everyone else can.
We're
If you
doing a
can.
negotiation with the hotel this afternoon, and we've insisted that the hotels bring the clients rather than the lawyers. We want the lawyers to come, but we want the clients here because there's more reasonableness in the discussions, because the lawyers get set on what's best for their clients, so the clients can actually work out the details and they become more reasonable. So today, though, the client isn't coming, and I can tell you there's not going to be a great chance that we'll settle this out today.
One of the things that happens, and I hate to disabuse some of the law students in this room, we lawyers can get in the way. We can cause problems. We get our egos into it. We feel an obligation to protect our clients' interests, and we may be more assertive or adversarial for our clients than we necessarily would be for ourselves. And so there are times where actually having the clients there and participate in one of these processes is really helpful, contrary to the fears that a lot of lawyers have. Sometimes actually having the clients there is counterproductive. Sometimes the lawyers, and very often, and there's a lot of empirical research that suggests actually lawyers, particularly experienced lawyers, realize that it's really in their interest to be reasonable and to work together. Doesn't mean you're going to roll over and necessarily give the other side what they want, but that it's in their interest and their client's interest to be reasonable, and that the parties often are so emotionally upset that involving them in the room may be counterproductive. So one of the lessons about all of these things is I say that none of these processes is the best process or should be used in every case. What I argue is that these are more choices and that lawyers and parties should consider this range of choices and consider which one and consider what the configuration should be, whether it makes sense to have the clients in the room or not. So what you said is a good reason in terms of why you might want to have this kind of four-way meeting and bring the parties involved. Why might, just kind of going back to this idea of, let's say you have a commercial dispute, why might you want to have this big C cooperative process where there isn't a disqualification agreement as opposed to a collaborative where there is a disqualification agreement?
If you have like in-house counsel and stuff, your in-house counsel gets cut out of the litigation if they're part of the collaborative, I guess, instead versus cooperative.
That's been a huge problem for the collaborative lawyers, and one of the reasons why it hasn't worked so well in terms of some of the non-family. So that's one reason. Any other reasons why in the non-family context you can imagine? Well, let me give you a hypothetical. You've got a case. Maybe I'm not sure what let's just say it's this contract case between a hospital and a supplier. I don't know what it is, but we'll just say that's what it is. And you have a collaborative, big C collaborative process. You've signed a disqualification agreement, and you negotiate for a while, and you can't reach an agreement. Then what happens? You're out of the picture. And then where does your client go? Your client goes to your competitor down the street. And your competitor down the street not only gets a much more lucrative case because litigation, well, you can generate a lot of billings on litigation. I mean, this is not for people who want to make a lot of money. This isn't the goal of it. It's basically to help parties. I think you can make money, you can have a good living, but if you're really looking to crank out a lot of billings, you're going to do it from litigation. So if you do a collaborative case, you sign this participation agreement with a disqualification agreement. It doesn't settle. Your client, not only do you go and lose the client for that case, but you're afraid that that client is going to stick with the other law firm for the next case. So you may lose the client all, for good. In the divorce context, most lawyers aren't so much thinking about wanting to get the client for their second, third, or fourth divorce. They aren't looking for repeat business in that context. Often, actually, one of the collaborative lawyers is saying certainly the collaborative lawyers, part of the reason they do this is that they hate going to litigation, they hate going to trial. And there's a lot of good reasons for that. That's, some people really get into the game and get into litigation, into trial. A lot of people, and I suspect a lot of people in this room, probably are not those folks, would much prefer to work out something reasonable through negotiation. So part of it is that you are going to, the risk is that you're going to, so that the collaborative lawyers in the family context don't want to, they don't really care about losing this case. They're not so much looking at repeat business. And they have, in general, their portfolio, their docket consists of a larger number of smaller cases of people who are not repeat clients. As compared to, in the non-family civil context, you tend to have a smaller number of clients, smaller number of cases, bigger amounts, so you're going to lose more in an individual case, and these are repeat players who are repeat clients that you're going to lose. So in the non-family context, one of the things I think God bless the folks who are trying to do this in the collaborative context. I have to say, I'm not expecting that they're going to be very successful. I think there's a lot more room for using this big C cooperative process in the non-family cases, but also in some of the family cases. One of the things is that you do have this opportunity for going to litigation. One of the lawyers who I interviewed and going to litigation in the big C cooperative process and then going back to negotiation. One of the lawyers I interviewed for my study of the Wisconsin lawyers said, sometimes people need reality therapy. And by that she meant they need to have somebody sitting on a high bench wearing a black dress telling the parties this is the way it's going to be for a while. So there's a temporary order at the beginning of the divorce, and they need to hear it from a judge, and then they hear it from the judge, and then they're ready to go back and negotiate constructively. So having the same lawyers be able to go into litigation, have that temporary order hearing, and then go back is a positive thing. One of the other things that one of the lawyers in the study talked about was that if you do need to go to litigation, you can actually have cooperative litigation. Now, for some of you, that may sound like an oxymoron. Let me say it again, cooperative litigation. What they're saying is, and actually, this goes on a lot more than people might expect. I mean, part of it is that the rules of civil procedure and that the reforms in recent years have been encouraging lawyers to work together, certainly in the federal rules, to get together, plan, develop a joint game plan, share information, develop lists of experts and things like that. But just because you have the rules doesn't mean you have the people have the motivation to actually do it. In the cooperative process, you can not only have the letter of that, but you can also have the spirit. And so one of the lawyers said you can actually have some really good litigation where there are people reasonably disagreeing about the facts of the law, and you really need to have some third-party judge make some decision, and then and that can be a fine thing. So part of it is you can. One of the advantages of the Big C process, Big C cooperative process, is that you can go back and forth between litigation and negotiation with the same lawyers. And if you do need litigation, it can be a sort of the way litigation is supposed to be. There's nothing that says, I mean, if you look at the rules of civil procedure, it doesn't say lawyers have to act like jerks. I don't think there's a rule. Is there a rule that says that?
No.
No. Okay. You do not have to act like a jerk when you're litigating. So part of this is to try and create, sort of have lawyers act the way, sort of the rules, and actually if you look at the rules of professional responsibility, they don't tell lawyers that you have to act like jerks either. And in fact, if some readings of it say that you really shouldn't. So there are some advantages of the Big C cooperative process. What are some disadvantages? Why, if you were a party, why might you prefer a Big C collaborative process over a Big C cooperative? Go ahead.
Maybe you feel that it's going to motivate your lawyer more if you're in a collaborative process than in cooperative.
Right.
They're not going to feel like they just want to go to litigation to get the big payout.
That's exactly right. Go ahead.
If I was involved, I'd be more willing to discuss like the facts of the case and maybe, concede a little more to the other side because I wouldn't worry about the other lawyer using that against me in litigation.
And that's one of the things that is commonly said. I think it's a huge fiction, but I think a lot of people, lawyers and clients, believe that. And in some ways, there's an analogy in the mediation context. You may know about the Uniform Mediation Act and various statutes and rules that provide privilege or other protections to make sure that the communications in mediation aren't disclosed in a litigation process. The same sort of logic here. Often the participation agreements provide for confidentiality protection. The Uniform Collaborative Law Act is modeled, the privilege provisions are modeled very closely on the Uniform Mediation Act, so it's designed to protect it, the communications. And although I say it's illusory because there's this rule that independently discoverable evidence is still admissible. So let's just say I'm in a mediation or a collaborative negotiation with Ray, and he tells me something damaging to him. He tells me about where he's hidden his secret bank account. Well, let's say he's a party in a collaborative process. The lawyer, his collaborative lawyer, when he gets to litigation, can't represent him in litigation, but the other party knows darn well that what Ray just said, and then you can't put Ray on the witness stand and say, isn't it true that you said in mediation or in a collaborative process that you hid your assets in a Swiss bank account, but you know where to look. So that's why I think this is somewhat illusory, but it does give people that sense of comfort and confidence that those same lawyers, the collaborative lawyers, are not going to be the ones who are going to be cross-examining them. And indeed, it may create a more constructive, positive negotiating environment than in the cooperative model, where the lawyers may, in fact, have in the back of their mind, well, gosh, this case may not settle, and so I need to be thinking about how I can prepare the case for trial if I actually need to go to trial. So I've heard some people say that the dynamics in a collaborative process tend to be more constructive and positive and cooperative than in a cooperative case, although I've also heard that there are some real stinker collaborative cases that I think most collaborative lawyers can say, oh my God, I can't believe some case where the supposed collaborative lawyer on the other side was just being a pain in the neck. And I've also heard about cooperative cases where the fact that they didn't have a disqualification agreement didn't preclude them from having a very positive, constructive environment. So there are advantages to each one, there are risks to each one. Bob, what were you going to say?
Yeah, there are three other things. Number one is we're now seeing a lot of corporations or larger entities being hit financially by the recession, and they look at their budgets for litigation and costs and potentially high or adverse consequences to litigation. And number two, these processes, the cooperative and collaborative, focus on problem solving in the beginning. So even if you have a construction dispute, if you might end up with liens and all this, your project's going to be screwed up for a while. It may cost you a lot of money to delay those processes, where these engage in problem solving up front. And number three, this is particularly useful if you have ongoing business relations, a vendor, purchaser, or contractors, subcontractors, and the like, where you want to maintain that business relationship for longer term purposes. If you end up in litigation, your relationship very likely is over with permanently. So you got to look at what your values are long term as well as short term.
Mm-hmm. I want to pick up on the last point that you mentioned, because it makes me think about how you probably have heard that a lot of contracts these days have mediation or ADR clauses in them. And one option would be, let's say you have a commercial dispute and they've got a contract and it has a mediation clause. Well, maybe they'll start off in mediation, but it may take a while. And actually, of course, obviously I didn't put mediation up on this chart, and that's another option here. And when you're having, some cases where you have a mediator, the lawyers aren't involved. This tends to be some family cases, and in a lot of places that's the norm. The parties may not have lawyers at all, or they don't attend the process. They sort of coach from their advice from the sidelines. Sometimes you have the parties the lawyers will be involved, and you have a mediator in addition to the two lawyers and the two parties. One of the virtues about this, and one of the reasons that I'm so interested in these two processes, as far as I'm concerned, this is what lawyers should be doing as a normal course of life. And you don't necessarily need a mediator. Because sometimes you do need a mediator. Sometimes, even when the best of will, and you have good lawyers who are motivated and create structures and incentives, you can't solve a problem, and having a mediator there is important. But one of the things that's happened in some places where you have mandatory mediation process is lawyers learn that, well, the case is probably going to go to mediation. I might as well just kind of go through this traditional process from the outset, and then we'll get it settled in mediation later on. So in some ways it has this perverse effect of discouraging negotiation by lawyers, because people are going to figure they're going to have to go to mediation elsewhere. This, from my perspective, is what lawyers should be doing should normally be doing. Not every case. You may have cases where you really have a party on the other side you can't trust, and you really need to use a litigation process. I wouldn't say you should never use a litigation process, but having all three of these in your toolbox and having it as an option to consider, I think, is really important. There's this famous saying, apparently, that Henry Ford, when he invented the Model T car, said, you can have this car in any color you want as long as it's black. Well, it used to be you could have, a dispute resolution you wanted in any color you wanted as long as there was a litigation process. Well, what the ADR movement in general has been about is to say, hey, there are a wide range of options, mediation and arbitration and a ton of hybrids, and these are more options. And what is, for me, motivates me is that these are, and I'm a law professor. I teach a course called lawyering. It's a required first-year course at the University of Missouri, and it's about how lawyers should be thinking about what their jobs are, which is to advance your client's best interest. Sometimes you really need to use a litigation model. Often you don't. And even with a collaborative and cooperative, you can still go to litigation. Certainly, especially with a cooperative model, it's relatively easy to go to litigation. So I guess what I'm saying is I want you to be thinking about all of these as options and to include them in your toolbox and to advise your clients about them. Go ahead.
I'm wondering whether the family law context, these models are actually a lot closer together than they are in other contexts for a couple of reasons. First of all, I think in divorces, it's probably the case that the parties know a lot about each other, have access to each other's financial records, or what have been joint financial records. There's a lot of transparency in terms of they don't really need a formal discovery process. The lawyers might need a formal discovery process to get documents from the other side, but the parties are often very aware of the facts and the situation, and they also probably do a lot of communicating. It's not that, I mean, as they're going through the divorce, they're talking a lot to each other anyway. And so it's less like parties that are involved in some other kind of contract dispute or something where there might need to be more formal discovery to get stuff, more ability to hide stuff, and more ability for the lawyers to say, don't talk to the other side. But also, even in the collaborative, divorce is not the kind of thing that can be settled by a private agreement. You have to go to court in order to get a divorce. So it's just it's not really a question of whether you're going to litigate. You're going to go into court and get a judgment. It's just a question of whether you're going to litigate the dispute or negotiate the dispute and go into court with stuff settled. But the court is still going to have a process that you're going to have to avail yourself of in order to achieve the outcome.
Certainly in the United States, for divorces, the way we're set up, you do need to do that. Other countries, you know, they have administrative agencies, so you don't have to, if you're going to get a divorce, you may go to some agency which will process the papers. You're right that in the United States you're going to have to engage in litigation, at least formally. The big difference, and maybe what we should talk about here, is contested litigation. So you don't necessarily get involved in contested litigation.
But even under what you're calling the litigation model, or the traditional litigation model, first of all, a large percentage of the people that go through that process are not represented by lawyers at all.
Right.
And then of the ones that are represented by lawyers, a large number of them resolve it through settlement. So I mean, a small percentage of the cases are actually resolved through litigation, and it seems like even without the collaborative or the cooperative movement coming, I mean, I practiced family law in Wisconsin. I left in 2001 or 2000, so it was just as this collaborative movement was heating up there, and I remember the people that were starting the collaborative divorce networks and so forth. But even before those came in the early 2000s, most lawyers were trying to reach settlements in divorce cases and talk their clients down and say, you really want to go into court with a settlement. The judge really doesn't want to hear this kind of argument. You know, doesn't really want to waste time. You know, would prefer to have you work it out.
Sure. You raise a couple things I want to respond to, and hopefully I'll remember to. First, let me say, obviously, this graphic doesn't cover the waterfront. So you have lots of cases where one or both party are not represented. And that's a huge part of the court's docket, particularly in family law cases. Part of it is that parties can't afford the lawyers. Part of it is that it's shocking for those of you who have legal training or are getting it to believe, but some of them don't like lawyers. Some of them think that we are nasty people who stir up conflict, cost way too darn much, and they can do it on their own. And some of them actually can do it on their own. So this doesn't cover everything. Basically, these are models where basically you have both parties have lawyers, and it doesn't include mediation. So there's a lot that's excluded, and you're right about that. You're also right, and you know, I alluded to this earlier on, that lots of lawyers are small C cooperative. They negotiate reasonably all the time. So the real question next, which I guess I want to pick up from your comment, is, well, if people are doing small C cooperative law all the time, why should they use a big C process? And let me talk a little bit about it. You have in your packets, which you don't need to turn to now, a participation agreement. It's a written agreement that has a number of provisions that sort of structure the process and say, you know, we're going to exchange information voluntarily. We're going to negotiate in good faith. We're going to try and agree on joint experts instead of having separate experts. That sort of thing is in the participation agreement. So what's the advantage of having a big C process, either a big C collaborative or cooperative, as opposed to a small C process? Why would you even think about having an agreement to negotiate, participation agreement? Is there any advantage? Go ahead.
Well, it seems to me like the four-way meeting is a process that has arisen out of the development of these movements, and it's it would be an unusual thing in people that were thinking in terms of traditional litigation, and to the extent that it's efficient, and it could reduce the cost for everybody.
Okay, and of course, it also, particularly in the divorce context, it's important because, if you have divorcing parents who are going to have to interact with each other on an ongoing basis after the divorce, having a good, constructive communication process to resolve the dispute is a helpful thing. Other advantages of why you might want to have a formal big C process as opposed to a small C process? Go ahead.
If it's formal, there's set rules and everyone agrees to them in advance.
So you may have more commitment to it, particularly for the parties. I mean, one of the things is, Gene and I have been, we've been in practice for a long time. We've known each other, and we've had lots of cases together. We may not need to have something formal. Our parties have not done this. They may need to have the structure. They may need to have the value of having it written out and having sort of guidelines or rules for it. And it actually can help if there are problems that come along. So I think that there actually is an advantage to having some kind of written agreement. One of the other things I guess I wanted to comment on in terms of one of the differences in practice between the collaborative and cooperative, and particularly in the Wisconsin, what I found was that some of the collaborative lawyers, the cooperative lawyers there, do both collaborative and cooperative. There's some people who only do collaborative, some who only do cooperative, and there's some who will do both. Some of the folks who do the cooperative, and of course this was generated as a response to their dissatisfaction with collaborative as an exclusive one of these processes, is that the way they experienced it in Wisconsin, and I suspect it's true in other places, it's sort of too formal. That they're too formalized in terms of saying that everything needs to be in a four-way meeting. It may be a good idea to have some four-way meetings, but maybe it would be more efficient and more productive to have just lawyers having some conversations between each other, not necessarily to having a full team of collaborative professionals. So one of the things that some of the Wisconsin cooperative lawyers are frustrated about, even those who do collaborative cases, is that this is sort of overkill for some cases, and for some clients, you can't afford it. Particularly, there's one of the things that's very popular and sort of, I don't know how much it's the norm, but sort of among the collaborative circles these days is that cases should have these interdisciplinary teams. And the teams may include not only two lawyers, but may have a coach for each party, or sometimes they'll just have one coach for both parties, a joint mental health professional, a joint financial professional. So you can have the supposedly four-way meeting, you can have a large group of people in a room, and you can just sort of imagine what the ticker is costing. And so part of one of the things that the cooperative model and the folks have been saying is that they want to have a more efficient process. Now, to be fair, the collaborative lawyer is saying, well, we actually don't necessarily do this so rigidly all the time. In any case, we often will be more flexible about the process. But that's the other difference that I observed in my study. We've got a couple more minutes. Let me see. You've been a great group, and I have to say I appreciate, particularly among the students, their willingness to be called on and volunteer. Let me stop and see if there are more questions or comments or observations. Go ahead.
Is this ever used in cases with multiple parties, or class actions or stuff like that?
They're wanting to. One of the things is this cooperative, the formal cooperative process is so new, and it really isn't being used widely yet. The Uniform Collaborative Law Act was drafted in such a way that would permit that, theoretically. For the reasons I've described, I would be shocked if you had very many in the collaborative process. I could imagine it quite easily in the cooperative process. One of the things is that you can hear that this is something that I think is important, and I've actually made it a mission of mine to go out and talk to folks. So in addition to the folks, and try and encourage people to offer both cooperative as well as collaborative. So in addition to coming here to Las Vegas, next month I'm going to, or later this month I'm going to Minneapolis, and there's a group there that is forming, folks in Seattle that are interested in doing it in Cleveland. So although cooperative has started later and is much smaller, and I don't know whether it'll get as big or not, I suspect not, I suspect that this is something that you're going to see more of. One of the things that saddens me is that there's this really pathetic competition and dissing, almost like kids in a sandbox, why people don't offer both of them. Many of the collaborative folks, as I say, don't think that the collaborative is a real model. They think it's really no different than traditional litigation. Many of the collaborative folks don't respect the collaborative. They think there's risk of oppression. They feel like they're of clients taking advantage of each other, and that the costs are too much and it's too rigid. I think that both of them are legitimate, and I hope that people will offer them, including many of you when you're off in practice. Other questions, comments? I saw another hand somewhere. Go ahead.
Do either of the big C models in the negotiation process involve a neutral decision maker, like a mediator or an arbitrator?
I'm glad you asked that. They can. One of the things I found in my study in Wisconsin, one of the things is they don't actually use normally a written participation agreement, in part because it's a relatively small group of lawyers who know each other, so they do this informally. One of the informal norms that they have is that if they do get into trouble, that they will use a mediator. So that, I understand, is very common. In the collaborative process, what I have heard from folks is that they don't use a mediator because they got so many other professionals involved, and that, for example, if you have a coach or a joint mental health professional, they may function to some extent like a mediator, but that when a collaborative process is in trouble, the parties are very reluctant to hire a mediator because they've already invested a huge amount of time and energy and money in the collaborative process, and they figure if they haven't settled it by that point, they don't use the mediator. That's what I've heard. I imagine, I'm sure that there are some of the collaborative cases where mediators are used, but I gather it's much less common. So I guess that's what I've heard. Other questions, comments? Go ahead.
It seems to me like if they got into trouble, they'd want to get a mediator, though, because that's their way of getting around the whole going to litigation thing and losing their clients, and it'd be more costly to the parties. Is that a reason for bringing in a mediator, even if it's more costly?
It would be. It makes logical sense, and I'm sure that there are some collaborative cases where they do. It just doesn't seem to be the norm from what I've heard. And one of the things is that there are these local practice groups all around the country, and there's local practice culture. So the way people practice it in one area may be very different from another. I'm sure that that is true. So there may be some practice groups where the norm is to bring in a mediator in the collaborative process. Okay, Bob?
Yeah, just a thought, John. One thing that's beautiful about the collaborative movement that I've happened to be participating in for a number of years is that it's in a state of growth and development and creative endeavors. And to give you an example, let's say you're in a collaborative model and you got down to one dispute you couldn't resolve, rather than with the expense of litigation, you might just say, let's craft a deal where we have a binding arbitration on this one issue. You do it quickly with a private arbitrator. That resolves your impasse, and then you can go on and submit your paperwork for a divorce. So there's all kinds of creative, blends of different processes that are going on now, and every month or every few months you hear of new ways that these things are being done. Mm-hmm. And that's the beauty of the whole movement. There certainly is some flexibility, as you probably know, within the collaborative movement. That's the idea of using arbitration is a controversial issue. Some people think, for just the reasons that Bob has described, that can be a very constructive thing. Others say arbitration is inherently an adversarial process, and that lawyers get back into their adversarial mindset, because if you're in an arbitration process, your goal is to win, not to have a win-win solution. But it's certainly an option for some. We have time for one more question or comment if someone has one. Go ahead.
Well, it seems to me, maybe I'm wrong, but in the third
collaborative here.
Yes. The parties are pressed to settle. I feel like they will be pressed to settle, and especially in domestic cases, they don't want to settle. They just want to go one, after another. So I think, it's just sometimes it doesn't work in some cases. Would the clients really want to be pressed to settle? What if they just don't want to?
Well, some of them actually do want to be pressed to settle. They really don't want to go to court. And in some ways, really, the choice here is, pick your poison. Are you more wary about the pressure of litigation in a cooperative model or a traditional litigation model? If you're worried about litigation, then you may be more willing to be pressed to settle in a collaborative case. If you're wary about the pressure in negotiation and you're willing to take your chances of the pressures of litigation, then you probably want a cooperative process. The other thing I would say, I used to practice family law, and there's this image that divorcing couples are all hostile and mean and terrible to each other. This wasn't my experience. Certainly there are some of those, but many of them, some of them are what one of my friends called pre-shrunk. They would come to me after they'd gone to a therapist. They'd worked out the emotional issues, and they were ready to do the legal divorce. And those were a piece of cake. And even when they weren't pre-shrunk formally because of having gone to therapists, they, a lot of them actually care about and respect each other. They may have grown apart. So one of the things is that some of the collaborative lawyers say, well, gosh, you really need this disqualification agreement to get people focused on being cooperative. Well, it ain't so. There are a lot of people who are very reasonable, responsible, respectful, cooperative folks who do that in any case and don't need the disqualification agreement. For some people, it's a helpful tool, and that's why I think it's a useful model to have out there. For other people, the risk that you describe is exactly right, and so one of the things that some of the collaborative lawyers talk about is how sometimes it's a hard sell to get clients to buy into this because they're afraid of just what you're talking about, which is why I believe that it's important to offer both of them so that parties can then have a choice which one they want, and both choices are legitimate. We should probably stop. So I want to thank all of you for coming and appreciate your attention.